issue of voluntariness of the defendant's statement upon his arrest, counsel applied for trial within trial, which the court granted. The trial within trial commenced immediately, whereupon the prosecution, in proof of the voluntariness of the said confessional statement, fielded one witness and led him in evidence to rebut the allegation of the defense, while the defense counsel immediately fielded the defendant as TDW1 as their sole witness. Now, trial within trial is a voir dire. That is, trial within trial is still a criminal trial, but may best be described as a mini trial within a trial. It is to ascertain the admissibility of the confessional statement of an accused person. See Boris Shade versus Federal Republic of Nigeria, 2012, 18 NWLR P347. In support and in rebuttal of an allegation that a statement was not made voluntarily. Once an objection is raised on the voluntariness of an extrajudicial statement, the court must call for trial within trial. This is because a confession in a statement made by an accused person which was not made freely and voluntarily cannot be admitted in evidence. See Boris Shade versus Federal Republic of Nigeria, Supra. See Ojegele versus State 1988, 1 NWLR, etc. In the case of Sani Abdullah and others versus the state, the issue was whether the voluntariness of a confessional statement will be tried with a trial within trial, but the JCA held that it is settled that an accused person confronted by the prosecution that he made a statement voluntarily must make his stand clear, either that he did not make the statement, in which case the court will rule after the submission by both parties, or that it was not voluntarily made due to some duress, undue influence, or coercion. In the former case, the court may admit the statement in evidence and assess its weight in the final decision. In the latter case, the voluntariness must be tried by what is called trial within trial. And if found to have been made voluntarily, it is admitted in evidence. If not, it is rejected as evidence. To resolve the issue, this court will refer to the testimony of the prosecution witness, CPW1, as well as the defendant himself as defense witness, CDW1, in the trial within trial for more elucidation and to ascertain the truth. The TPW1 testified thus: my names are Lawan Mohammed Abdulkadir. I'm a public servant working with the NDLEA Yobe State Command for 3 years. The way and manner of the procedures underwent when taking the statement of the defendant, after all the weighing and testing of the exhibit in the presence of the suspect, he was asked to write the statement on his own about the issue that led to his arrest. He said at the time he could not write. I was then asked by the officer that led the operation to record if the suspect agrees. He agreed that I should take his statement. I now cautioned him in English and translated for him in Hausa. We started from his biography, where he was born, schools attended, how he started selling drugs a year ago. He mentioned their names and even mentioned one is dead. The suppliers that he started getting supplies from at Asia in Jigawa State, and the profit he made of one block as of then was at around 4,500 Naira. That having recorded all this, I read the statement of the suspect in Hausa in the presence of other officers of the command and asked him whether that was what he told me. He said yes. After proofreading in Hausa language, and I asked him to translate from Hausa to English, he could not even sign. He was asked to print the statement, which he did. The suspect was not tortured, coerced, or promised. Even at the time of arrest, he was calm, he has been doing it for a long time. During cross-examination, the witness confirmed that he recorded the defendant's statement at 8:15 to 9:00 a.m. in the morning of that day. that the moment at dawn when everything can be seen was when the statement was taken, and none of the defendant's relatives or lawyer was present, that there was a team of 17 officers there, and that the statement was taken in an open space within the corridor of the command. The prosecuting counsel thereby closed his case. The matter continued immediately with the defense counsel, with the defense opening their case, whereby the defendant as a sole witness was called, and he testified thus: "My names are Damaturu. When I was brought from home to their office one Zabu, and was showed some exhibits, whether they are mine, I said no. They were writing, and he was asking me, and he was writing. I refused to talk, and he kept on talking. I insisted until I see my lawyer. They started beating me. I was also slapped. They filled some forms. One of them, Zabu took my hand, helped my thumb to thumbprint with force. After writing, I was locked. Then they brought out some small forms and forced my hand. About 4 documents, and I asked about my relatives so I can get counsel, since it was a setup. During cross-examination, TDW1 confirmed that he's 28 years old, married, and had made a statement that he's a farmer and a businessman. When asked to agree that exhibit does not belong to him, he affirmed. But when asked whether that was what he gave in his statement, he refuted, stating, "Not mine. When they got it, it wasn't mine, and I do not know the owner." When further cross-examined, that there was no evidence that you are tortured as you allege or any injury, the witness stated that I was slapped and beaten with stick, and that's the reason why I'm yet back to my normal being as a result of the beating meted to me. Har yanzu kaina bai dawo seti ba dukan da aka mini. And when further asked if it is reasonable not to go to hospital till now, that he has been using traditional medicine to heal himself and did not go to the hospital as a full-grown man knowing his right, the witness answered, "Yes, I use traditional medicine." Thereby, the defense closed its cases in respect of the trial within trial, and both counsels submitted to court that they are waiving their final written address and also do not intend to address the court. Now, address by counsel are designed or tailored in line with the evidence on record to assist the court. In this case, both the prosecution and defense counsel deem it wise to waive the right to both written and oral address on the facts in contention in the trial within trial. In my humble but strong view, a judicial statement made by a defendant to the law enforcement agents like the police or NDLEA containing an assertion or admission of guilt and showing that the defendant participated in and is culpable for the commission of the offense for which he has been charged must be voluntarily made positive, unequivocal, and must amount to admission of guilt. And that is when such a statement can be called or termed confessional statement. The law is settled that it is the prosecution that has the honors to prove beyond reasonable doubt that the statement of the defendant was voluntarily made. See Section 29 sub 3 of the Evidence Act 2011. Several judicial authorities from the appellate courts are also in agreement that it is the prosecution that bears the burden of proving the voluntariness of a confessional statement. The standard of that proof is beyond reasonable doubt, as in all criminal cases. In the case of Augustine Ibemi versus the state 2013 10 NWLR, part 1362, page 333 at 360, the Apex Court per Chukuma NAJC stated the scope and purpose of trial within trial in that the function of a court in a trial within trial is narrowed down to determining solely the question of voluntariness of the statement in issue and not whether the statement is that of the accused person or improperly recorded. It boils down to the proposition that there's no way an accused person who has not acknowledged his alleged confessional statement sought to be tendered by the prosecution can come round in a trial within trial to object to his voluntariness. The absence of his locus to do otherwise so contained is indisputable. This assertion of the defense counsel that she is objecting to the admissibility of both the defendant's English and Hausa version of the statement sought to be tendered by the prosecution based on the fact that the defendant confided in her that the statement was not voluntarily recorded and urged the court to reject same and direct a trial within trial for the prosecution to prove the voluntariness of the statement. The defendant, in his testimony, stated that they were writing and he was asking me and he was writing. I refused to talk and he kept on talking. I insisted until I see my lawyer. They started beating me. I was also slapped. They filled some forms. One of them, Zabu, took my hand, held my thumb to thumbprint with force. After writing, I was locked up. Then they brought out some small forms and forced my hand, about 4 documents, and I asked about my relatives so that I can get counsel since it was a setup. The defendant, in his testimony, corroborated the TPW1 testimony as to the way and manner the statement of the defendant was recorded, that after all the weighing and testing of the exhibit in the presence of the suspect, he was asked to write the statement on his own about the issue that led to his arrest. He said at the time he could not write. I was then asked by the officer that led the operation to record if the suspect agrees. He agreed that I should take his statement. I now cautioned him in English and translated for him in Hausa. We started from his biography, where born, schools attended, how he started selling drugs a year ago. He mentioned their names and even mentioned one is dead. The suppliers that he started getting supplies from Hadeja in Jigawa, and the profit he made one block as of then at around 4,500 naira. That having recorded all this, I read the statement of the suspects in Hausa in the presence of other officers of the command and asked him whether that was what he told me. He said yes. After proofreading in Hausa, I asked him to translate from Hausa to English. He could not even sign. He was asked to thumbprint the statement, which he did. The suspect was not tortured, coerced, or promised even at the time of arrest. He was calm, as he has been doing it for a long time. During cross-examination, TDW1 confirmed that he recorded the TPW1 confirmed that he recorded the defendant's statement at 8:15 to 9:00 a.m. in the morning of that day. At the moment at dawn, when everything can be seen, was when the statement was taken, and none of the defendant's relatives or lawyers were present. That there was a team of 17 officers there, and the statement was taken in an open space within the corridor of the command. The law and precedents have made it clear that a retracted or challenged confessional statement does not really exonerate an accused person from the commission of an offense. The denial and allegation of an induced or implanted confessional statement is one that should engage judicial concern. However, such denial and allegation must be taken with a pinch of salt. A careful consideration of the circumstances of the alleged compelled confessional statement always reveals some character of voluntariness in the spillage. Some personal details which should be known to the appellant alone often expose the falsity of the allegation of compulsion. Per Dongbang mentioned JCA in the case of Obidiozo versus State, 1987 for NWLR, Part 67. I'm fortified in this line of thinking by the statutory flavor of Section 31 Evidence Act 2011, which reads, if a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the defendant for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been the form of these questions, or because he was not warned that he was not bound to make such statement, and that evidence of it might be given. This honorable court holds that from the above authority, the testimony has not created doubts in my mind as to the voluntariness of the extrajudicial statement recorded for the defendant, even after taking into account promise or inducement that allegedly occurred during the recording of the extrajudicial statement as complained about by the TDW1. From my evaluation of the evidence before this court in the trial, within trial, vis-a-vis the confessional statement being relevant, therefore, there does not exist cogent reasons to doubt the voluntariness of the statement gotten as a result of promise, as the National Assembly has since taken care of the defendant's complaint by introducing a fresh provision to the Evidence Act 2011 Cap E14 laws of the Federation of Nigeria 2011 to make confession obtained by promise or secrecy admissible if the confession is relevant. That is contained in Section 31 of the Evidence Act, which is already reproduced for ease of comprehension. This honorable court, by the above analysis, determined that the prosecution has established that the extrajudicial statement of the defendant was made voluntarily to the extent that I am satisfied and feel sure about it after hearing evidence on either side. Therefore, the extrajudicial statement of the defendant, dated the 18th day of June 2022, sought to be tendered by the prosecution, which was objected to by the defense and for which this court conducted trial within trial for its admissibility, is hereby tendered and marked Exhibit NDLEA Adamu 4. Consequently, the objection of the defense is overruled, and it is hereby ordered that this trial proceed with the continuation of the examination in chief of PW2. The matter is hereby adjourned to, give me a date, Register of Court. 29th April.
My Lord, we are most grateful.
Just a minute. This matter is hereby adjourned to the 29th day of April 2025. Proceedings to be by virtual mode. This shall be the ruling of this court.
As the court pleases. We are most grateful, my Lord. Thank you for this sound ruling. Thank you, my Lord.
Okay.
/DR/47/2022 between the Federal Republic of Nigeria and Usman Alhaji Nepa.
Can you unmute the device? Correctional Center.
Yes, my Lord, the defendant is, yeah, the correction center prison.
Okay.
Thank you.
Representation. Representation. Yeah. Yes, thank you. Date, give me a date. This case is called. The defendant is present before the court. The defense counsel is absent. The registrar of court adverted the court's attention to a letter of adjournment forwarded by the prosecuting counsel. The application is granted. Matter is hereby adjourned to the 29th day of April 2025. Proceedings to be by virtual mode. The defendant is to continue to be remanded at the Potiskum Correctional Center to the next adjourned date.
As court, please, my lord.
Salisu,
Yes, my lord.
explain to the defendant that both the prosecuting and defense counsel are not before the court. That is why the matter cannot go on.
As court, please, my lord. Malam Usman, yau ne za a gudanar da shari'a, amma bisa ga lauya mai kare ka da kuma lauya da ke gabatar da kara ba su bayyana a gaban kotu ba. Shine kotu daga zuwa ranar 29 ga wannan watan 4.
Thank you. Call the next case.
Charge number FSC/TM/CM/7/2024 between the Federal Republic of Nigeria and Abdullahi Ali.
Are they okay?
Hello.
No, don't cause, okay, is counsel there?
My Lord, I'm present, my Lord.
Okay.
Yes, my Lord. Defendant is in court and is his house.
The presentation?
With profound humility, my Lord. J. Abdul Qadir is my name. My Lord, I humbly and respectfully announce my appearance for the complainant, my Lord.
Yes. Defense counsel? No counsel for the defense?
Waziri, you are muted. Please, unmute yourself.
AI Waziri, can you unmute your device? Can you hear us? If you can hear us, then unmute your device. There's a red button on your device. You need to touch that button to unmute your device. AI Waziri, can you hear me? You need to touch a button on your own device to unmute yourself.
My Lord,
Yes.
with profound respect and humility to my Lord,
I can hear you, but I can't see you.
okay, my Lord.
You have muted yourself again. I can see you, but you have muted yourself again.
I'm trying to.
Okay.
Yes, you are. With profound respect and humility to my Lord. Hello, my Lord.
Go ahead.
Yes, with profound respect and humility to my Lord, I am AI Waziri, humbly announcing my appearance for the defendant, my Lord.
Yes.
My Lord, the matter was adjourned today for cross-examination, my Lord. And subject to the convenience of the court, the witness is here and is ready.
We are equally ready, my Lord.
Who is the witness? Where is the witness?
I, Aminu, do solemnly swear before this honorable court that whatever I shall say in this matter will be nothing but the truth. So help me God. Thank you, my Lord.
PW1 has affirmed himself. He's male, adult, and MC.
Yes. Yes. Waziri, we are waiting for you. Defense counsel, are you still there?
Yes, yes, my Lord, I'm still here.
So what are you waiting for?
We are equally ready, my Lord.
Counsel, what is this matter for?
It's slated for cross-examination.
Then what are you waiting for?
Thank you, my Lord. We have questions for the witness, my lord. Mr. You are the one who investigated this matter, am I right?
Yes, of course, you are right.
Good. There are other suspects, if I may say, there are other suspects that you come across during your investigation who are not before this honorable court right now. Am I right?
Yes, you are very right.
Can you mention this name of this
Just
suspect?
a minute, counsel. You have
Thank
to realize
I
that I'm
apologize.
trying to write. I'm trying to record whatever is being said. So after asking your question, you wait. I'll record you before his response. So it's not as if you're having
Yes,
a
my lord.
conversation between yourself. Your
Much guided,
question
my lord.
was? Yes, thank you. Your question again?
Okay, my lord.
Can you repeat the question you just asked?
Thank you, my lord. Yes, the question is, this suspect, can you mention their names?
Before
That
then,
they were
what
not
was the
before the court?
question you asked? You said there were other suspects in this case?
Yes, of
Yes,
course,
my
there
lord,
are.
who are not before the court right now.
Yes.
So I asked him,
Yes.
yeah, can he mention the name of these suspects?
Okay.
Yes, there are one Mohammed Haruna and Bashir Barka.
Counsel, stop wasting time. You have so many cases.
Yes, my lord. So these two people you mentioned, will I be correct to say they are the real suspect in this, during your investigation? They are the real suspect to this matter? Will I be
No,
right to say?
no, they are not the actual.
During your investigation, the accused person standing trial, during your investigation, the accused person standing trial informed you that these two people you mentioned informed you that these two people you mentioned were the actual owners of the exhibits that were found with him. Am I correct?
Yes.
Did you get the question?
Please, pardon?
I said during your investigation, the accused person standing trial right now informed you that these two people you mentioned their name were the actual owners of the goods or exhibits that were found with him. Am I correct?
No, that is not correct.
Pardon?
Yes, I said that is not correct. He didn't
Okay,
tell
that
me
is not
that they
correct.
are. Yes. The one he told about were one Bayanzi and Mohammed.
That is,
One Mohammed.
don't worry, don't worry.
Yes.
Then please, can you explain why are they suspects?
You mean the ones that I've mentioned?
Since the ones you mentioned, you said they were suspect and they are not before the
I'm
court.
not clear with the question, please.
You just answered me that
Yes.
I am not correct. These people were the defendant did not inform you of that.
Yes.
So that's why I'm asking you. Then why are they suspects? Since you answered in the affirmative that I wasn't correct, that the defendant informed you about them. You said I'm not correct. Then I'm asking you now, why are they suspects then?
Told me that were the actual owners of these items were one Bayanzi and Mohammed of Makinta Kururi village of Kaga local government area.
Can you repeat the names again?
Yes, my lord. The question
no,
is...
not the question, not the question. He just mentioned some names. I wanted him to repeat what he just said.
As the court pleases, my lord.
He said, he told me the owners of the items were Mr. Kolobulama, can you hear me?
Yes, I can hear you, my lord.
Yes, I said repeat what you just stated.
Yes, my lord. What I was trying to say was that the two people that I earlier mentioned, that is Mohammed Haruna and Bashir Barka, were the driver of the truck vehicle and the motor boy, respectively. While
just
the
a
one
minute.
that you
Just a minute. Yes.
While those ones that I mentioned, that is Bayanzi and Mohammed, were the one who, according to the suspect, who initially owned the item and brought them to him and sold it to him.
Just a minute. I told you earlier, I'm trying to record. So when you just keep on talking, I'm not a machine. I'm trying to record what you are saying.
Sorry, my lord.
Yes, you are saying.
Yes, that the suspect actually did say that there were one Bayanzi and another one Mohammed.
Yes, they are the ones who initially
owned the exhibit, the items in question. That is the 441 railway sleepers, and were the one who brought and sold it to him. Damaturu.
Yes. Is the defense counsel there?
Yes, my lord. Officer, you just mentioned that Banzi and Mohammed sold it to the accused person.
Yes.
But isn't it during your investigation?
Yes, it was during the investigation that The accused person revealed it.
I didn't finish the question because my lord is writing. You just mentioned that they sold it to him, Banzi and Mohammed.
Yes.
But hasn't the accused person informed you? But hasn't the accused person informed you?
Yes, he did inform me while
wait for the question, please.
Yes, listen to the question. Allow him to finish the question before you answer.
Okay.
Thank you, my lord.
Yes, go ahead.
Hasn't the accused person informed you that he is only a guard? They only brought it to him so he will keep it before they will come and pick it? Hasn't the accused person informed you that he is only a keeper of those slippers? He is only a keeper. He is there to guard it so they will come and take it.
No, that was true.
Your response?
That is not true. That he is not only the keeper, but he bought it from them.
Is the defense counsel there?
Yes, my lord. Since you are certain he bought it during your investigation, do you know at what value he bought it?
Yes, he revealed that he bought each kilogram of the item at the cost of 150 naira.
At the cost of
100 naira each kilogram. And each slippers may weigh between 45 and 47 kilograms.
It's okay, we have ascertained the value.
Are you through with your questions?
Yes, my lord, I'm with my questions, my lord.
Are you through?
We have one last question for the witness.
Yes, go ahead. You're just wasting my time.
Sorry, my lord. From all you stated, you conducted an investigation on this matter thoroughly.
Yes.
Yes, all the information you now gave this honorable court, all the information you gave this honorable court, were informations told to you by the accused person standing trial. Am I right?
Yes, you are very right.
So you haven't go anywhere or conducted anything. It is just the statement of the accused person.
Pardon?
You answered the first question. You said, yes, I am right. My lord is writing.
Your question again. You started on another question.
Yes, after he answered the first, that I asked him, so since he said I am right, all the information he gave the court, from the information has been informed by the accused person. So I am asking him that means he hasn't conducted or find out anything on his own during the investigation. Am I right?
Yes.
I hope you had my last question. Officer, you had my last question.
Is the witness still there?
Officer?
The prosecuting counsel? They're online? They're offline? It seems they're having challenges. You know what is happening at that end? Prosecuting counsel? Is the registrar of court here? Can you call them and find out what is happening?
No.
If it's taking too long, we stand down this matter and continue with the others.
My lord, is it case number 4 that was called?
No, it's not number 4.
Okay.
The defense counsel?
Yes, my lord.
Maybe we should just stand it down for 10, 15 minutes while we're going to look at other cases. Just cannot keep
please,
just let's give it like 5-10 minutes.
As the court pleases, my lord.
What time is now? It's 11. Matters
It's 11,
Matters stood down to 11:30.
As the court pleases, my lord.
It's cool.
Charge number FSP/DM/CR/39/2022 between the Federal Republic of Nigeria and Garba Certain Powers.
All those at the correctional center. I prefer to finish with those from the correctional center instead of calling. That's the only case from the correctional center? Yes, it's better.
Yes.
Charge number FSC/DM/CR/23/2024 between the Federal Republic of Nigeria and Bamai Abdullahi.
Yes, my lord, the defendant is present.
Respect of this case by the prosecution counsel.
Representation? Any representation?
None.
Okay. Give me a date. This case is called. The defendant is present before the court at the Potiskum Correctional Center. The defense counsel is absent. The registrar of court adverted the court's attention to a letter of adjournment forwarded by the prosecuting counsel. This honorable court, having listened, looks at the application, hereby grants him. The matter is hereby adjourned to the 29th day of April 2025. The defendant is to continue to be remanded at the Potiskum Correctional Center at the next adjourned date, proceedings to be by virtual mode. Mr. Salis, can you explain the defendant?
Yes, my lord. Mama, yau ne za a ci gaba da shari'a ka. Lauyan da ya kawo kara da lauyan da yake kare ka duk ba su zo ba. Don haka, ranar 29 ga watan zuwa nan. In Allah ya kai.
Are those the cases for the correctional center?
Yes, my lord. That is all, my lord.
Okay, thank you, Mr. Salisu. Thank you, officer.
Very much, my lord. Happy nice day.
Okay. Call the next case then.
Case is /CM/CR/4/2023 between the Federal Republic of Nigeria and Garba Alhaji Alhassan.
Yes. Representation. Representation.
From the prosecution counsel, in respect of business.
My lord, I apply to be guided, my lord. Is it case number 4? Because the defendant's name is Garba Sarkin Power. Is it case number?
Yes, the case just called is Garba Sarkin Power.
Which case? It's Garba Alaji Alasa. The case number 5.
Okay.
Garba Alaji
Alasa.
Okay.
Case number 4 was
Garba
skipped.
Alaji Alhassan.
Okay.
Counsel, is that your case?
No, my case is case number 4. It was skipped, my lord.
Okay. Date. This matter slated for continuation of hearing is called. Neither the defendant or his counsel is before the court. The registrar of court adverted the court's attention to a letter of adjournment forwarded by the prosecuting counsel. Application granted. Matter is hereby adjourned to the 29th day of April 2025, 29th day of May. Okay, April 2025. The defendant is to continue to enjoy the bail granted him to the next adjourned date. Proceedings to be by virtual mode.
As the court pleases.
Yes.
Start number FS/DM/CR/39/2023 between the Federal Republic of Nigeria and Garba Sarkin Power.
Yes, my lord. The defendant is in court and is his house.
Representation.
May it please my lord, I'm M.A. Doya. appearing with Baba. Our respectful appearance is for the defendant, my lord.
Yes.
My lord, this matter is adjourned for continuation of hearing. The prosecution is not in court.
Yes.
But we don't know whether there is any communication from the prosecution, my lord.
You need to send it. Nobody.
Counsel, can you hear me?
Yes, I can hear you.
The prosecution counsel has sent a letter for adjournment in respect of this case.
Okay.
I even sent a text message to your principal.
When did he send the message? Because we could have communicated to our client.
Yesterday, I sent him a message. He even responded.
Okay. We are conceding to the adjournment, my lord. We are conceding the adjournment.
Date.
29.
It's better, all this April, it's better for you to take it to me. All these other cases, April is not good enough. There's Salah, there's what is it again? Easter, all this. So there are so many other cases. That's it.
My lord, we are suggesting that the matter be adjourned to 29th day of April 2025 for continuation of hearing. 29th day of April 2025 together.
29. Going to the convenience because of the attending program. Anyway, 29th, let's give it for 29th for now and see. This case is called. The defendant is present before the court. The registrar of court adverted the court's attention to a letter of adjournment forwarded by the prosecuting counsel. The defense counsel conceded to the application, matter adjourned to the 29th day of April 2025, the defendant is to continue to enjoy the bail granted him to the next adjourned date. Proceedings to be by virtual. Yes. Is that the only case?
Yes. This is the main
I
one.
just want to call the case again.
Call the case.
Charge number FST/CM/CR/7/2024 between the Federal Republic of Nigeria and Abdullahi Adam.
Provide humility, my lord.
Yes.
Once again, Joe Abdul is coming. My lord, we are sorry for the technical glitches earlier.
It's okay. Yes, is the defense counsel still here?
Yes, my lord, with profound respect and humility. My lord, I am AI Waziri. Now, assurance for the defendant, my lord.
Yes, go ahead.
Thank you, my lord. I had one last question. The question was, apart from the information you received from the defendant during your investigation, you have not found out anything on your own based on your investigation. Am I right?
No, that is not right. That is not correct.
In view of that, my lord, that is all for the witness.
Yes.
Yes, my lord, I say in view of that, that is all for the witness.
Yes.
My lord, there is no examination.
No, the examination counsel, I'm still waiting for you.
My lord, okay. In the circumstance, my lord, we shall be asking for a date to continue with our second and third witnesses, my lord.
Yes.
Suggest the date, counsel.
Subject to the, should be guided by the customary, my lord.
Okay. Counsel, 30th April.
It's convenient, my lord.
Yes, my lord, 30th April is also convenient.
Okay.
This much is hereby adjourned to the 30th day of April, 2025 on the concurrence of counsel. The defendant who is on bail is to continue to enjoy the bail granted him till the next adjourned date. Still virtual proceedings. Counsel.
My Lord, we are suggesting physical.
Okay.
Yes, subject to the court's convenience.
Yes, proceedings to be by the traditional mode of sitting.
As the court pleases. We are much grateful, my Lord.
Okay.
Thank you, my Lord.
Okay.
Okay, last one.
That is it for the day.
Thank you.
Thank you, my Lord. Have a wonderful night.
Thank you so much. Thank you, Counsel. Counsel, all those on this platform presently, I need you to pay attention. During virtual proceedings, it's always very stressful for me because I don't have your 100% attention. You're always distracted. I do not know the reason why. While in court during traditional sittings, you are calm. We conduct proceedings without any stress. But when it comes to virtual proceedings, as if you are distracted, you are not in one place. So I do not know what the problem is, or you're having problems with your gadgets. I do not know. So you need your 100% attention, just like I sit here from the beginning of the proceedings till the end. You cannot just on your gadget, leave, come back. It's just not done. It's very rude. At least you owe the court the courtesy of joining this proceeding from the beginning to the end. If you finish your proceedings, you apply to be let to go, but you just cannot at your own convenience appear and disappear. It's very rude. I do not understand, or there's any challenge you are having, please feel free to tell me so that we can see how we can rectify same. Is there a problem from the side of the court? From this side?
From our side, we've suffered technical glitch here in the office. That was why the device went off. We have to look for our technical assistants to come in and assist us, and that was why we came back, my Lord. We are sorry for the technical glitch.
Thank you, Counsel. I think next time, just like we do here, we have so many 2, 3, 4 gadgets at the same time, but we do not own all of them at the same time because it will interfere. So we have them standby just in case. So next time, please make sure that you have a standby device so that we have seamless proceedings. Any other thing that you discovered, any other challenge from any counsel?
Yes, my Lord. The challenges that I'm facing is that sometimes if I join the Zoom course session through Zoom, so I don't know whether the application that I'm using is outdated, or I don't know, it is somehow fluctuating. And I'm very sure of the data that I'm using with my network is stable. But I find it very difficult to log in to spend like 20 minutes, 30 minutes per minute on the course session without returning back to the main page. So this is the difficulty that I'm facing, my Lord.
Even from here, you're on, I can see you, but it's a bit blurred. It's not as clear as the others. I can see all the other counsel clearly, but your own is not very clear. So it could be a challenge on the network at your chambers. Yes, but if, because all in all, I think following the procedures of court will not take more than 1,000 or 2 naira for you to buy data, for you to follow procedures from the beginning because I know you have that at the back of your mind, your data is going, but this is also another challenge for council. I can understand that. But if you are low on data, just in case, we need to have a way of collaborating to inform council that they should be online whenever their case is going to be called, but it's going to be difficult. It's easier for council to be on the platform because usually if you cooperate, you find that the procedures are always very fast. We don't waste time.
Yes,
So I think, Mr. Ali Shatima Ali, the problem network from your own end, network problems. Yes, so we try to see how we can figure that out. Maybe, you see, I'll talk to the
Inshallah,
our technicians here as well.
Thank you, Malo, for the guidance.
Okay. Any other observation? None? Okay, I would like to thank council for being here. Thank you so much, as well as the staff of the Federal High Court. Thank you so much, as well as the Fortune Technologies. We really appreciate your assistance. Thank you, everybody, and do have a nice day.
Thank you, my lord.
Have a wonderful night.
Thank you.
Oh my God.